Richard Whish, welcome to Digital Markets Research Hub. Thank you very much for the opportunity to ask you a couple of questions, reviewing the main development in 2024 and maybe looking forward in 2025. It's a great honor to ask a couple of questions and continuously learning from you. I propose to begin with a fundamental reform or very ambitious reform introduced by DigiComp with new guidelines, draft guidelines on exclusionary abuses. It is a very fiercely discussed issue. Can you please provide your reflections on the trajectory of the development and maybe key elements of the reform?
Well, yes, I'm happy to do that. And as you say, there's a lot of discussion about all of this, and I think it's a process that's got a long way yet to go. I mean, the way I would introduce it would be to remind everybody that back in 2009, the Commission produced its guidance on its enforcement priorities. And now it's proposing to produce guidelines on the law. And there's only a few letters difference between guidance and guidelines, but of course they are terribly important, terribly different things. And back in 2009, that was the culmination of the process whereby many at the Commission itself wanted to, how shall I put it, reorientate the direction of travel for Article 102. I think there's a broad consensus that a pure form-based system to something as complicated as Article 102 just doesn't make sense. And of course, interventions, decisions should be in some sense connected to the adverse effects that a practice was likely to have. And so I think what the Commission was doing essentially way back then was saying, in selecting our cases, we're only going to investigate situations where we think there is a genuine problem in terms of the outcome of behaviours for consumers. And so that's about its administrative prioritisation of cases. And then the Commission says, in 2023, 24, we're in a very different world, because since 2009 we've had 27 Commission decisions. At the time of the original opening of the consultation, there had been 32 judgments of the court, and of course there have been more decisions and judgments since. And these cases have shed a lot of new light on things. And so we've seen digital platform cases, of course, jurisprudence discussing the as efficient competitor test, looking at multi-sided markets, looking at services that are provided free, lots of jurisprudence in which the court says the law isn't only concerned with direct harm to consumers, brackets, prices going up to the end consumer, close brackets, but we're also worried about detriment to the structure of the market and other kinds of indirect harm to consumers. So everything's come on a long, long way since 2009. And as I see it, the Commission says maybe now we've reached a point in time where we could try to put the corpus of decisional practice and jurisprudence into guidelines. And I do think there's a very important point here, incidentally. I was going to mention it later on, but I may as well mention it now. Of course, these would be guidelines for DG Comp and the judges of the General Court and the Court of Justice and the dominant firms out there who are the ones that get investigated, and their lawyers and their economists. But there are other stakeholders here as well. Maybe complainants who are not as well resourced as the DOMCOs, the national competition authorities that certainly aren't as well resourced as DG Comp, the judges in some of the member states that actually have very little or in many cases no experience of abusive dominance cases. And for them, this stuff is really, really difficult. And I think they could benefit hugely from some coherent, well-reasoned, well-presented set of guidelines. So that's what I see the commissioners setting out to do. And in the course of it, as one can see from the draft, they have looked deeply into the jurisprudence. And there are numerous references to case law, including recent case law, and references to cases where there were multi-sided markets or where there was a consideration of the as efficient competitor test. Ample references, of course, in the jurisprudence to competition on the merits. And then what the Commission has come up with is an attempt, as I see it, to draw all of this in to one document and provide, as it were, a template that would give rise to administrability in future enforcement of Article 102. Now, I have to say, I'm very sympathetic to all of the above. And when I saw the document, I thought it made a lot of sense. And I continue to think that. However, as we know, there's a huge amount of pushback of many different kinds, it has to be said. And I know a lot of people don't like the creation of what appears to be a two-step process, one asking whether particular conduct is competition on the merits, and then going on to consider how you demonstrate effects of particular kind of conducts which are not competition on the merits, and then proposing to, as it were, have a tripartite classification of some type of behaviours which are nakedly abusive, or one could say abusive by object. Controversial, but you could say that. There are other types of conduct for which there are well-established rules, like predatory pricing and pricing below some appropriate measure of cost. And then there are other cases where, frankly, it could only be on the basis of a full effects analysis that you can decide whether there's abusive behaviour. Now, to me, that all makes sense. But a lot of people don't like it. And in particular, they say, well, what happened to the as efficient competitor test? Why isn't there more of that there? And what do we mean by competition on the merits? It's just a sort of a vague expression that doesn't really have any reality to it. And dividing cases up in this way is form-based. And I thought we were meant to be getting away from a form-based approach. And then some people almost accuse the Commission of bad faith, that they're sort of bad backtracking on what they had said back in 2009. Well, I mean, let's wait and see what happens. I've not the slightest doubt that the document can be improved. I don't want to go sort of analytically into that now. I mean, any document can be improved. And this was the Commission's first stab. And they've had, let's face it, a 3-month consultation process, because this is difficult. Let's not beat about the bush. This is difficult stuff. What is an abuse of a dominant position? The person who eventually comes up with the E equals MC squared of that will win the Nobel Prize for competition law and policy. So we're looking for something which is very, very difficult. And there will have been an enormous array of responses, and the Commission or DG Comp, the legal service, whoever, have now got to go away and think about it, and they will come up with something in due course, which will not be the same as the original draft. I mean, that's absolutely inevitable, because any document can be improved. But where it will go and what the new Commission will want to do with it, well, your guess is as good as mine.
It is obviously very it's not very prudent to examine the draft document before the next version will be published and response to consultation. But if there is anything in the published draft which appears to be particularly interesting, or it shouldn't be scrutinized in isolation with other elements. So if you can identify, select something which is problematic or and interesting, and if not, maybe you can tell us your understanding, your kind of prediction of the impact of the guidelines in whatever form it will be published, how much will change in the daily enforcement of this category of cases?
Well, I don't want to start going into the document now because I mean, my feeling there is I'm sure they have got a vast number of responses, and they will have ranged from I like it, I hate it, and all sorts of other intermediate positions. I don't particularly see the value of me adding anything to all of that. What I hope will come out of it is a document which provides, as I said earlier, a kind of a template that will enable not the sophisticates of this business, but the authorities, the judges, the lawyers and the economists and the companies who don't have daily exposure to all of this stuff, and yet who might be abusing or being abused, or who might be being called on to adjudicate on abuse. And what they find at the moment is, frankly, really all rather complicated and rather confusing. And to try to bring everything together into a single document seems to me to be a very valuable exercise. And there are lots of stakeholders other than, as I say, the sophisticated DOMCO industry. There are lots of stakeholders out there that would benefit greatly from something which is usable.
And this is a question which is also related to the DMA. Do you think when the stakes are so high, when billions are on the table, it's even possible to draft a juristic text which would be insulated from its susceptibility of being complicated and getting more cryptic and thus interpretable in different directions? And if the answer is no to one or two, is the answer is also no to the DMA and the DMCCA?
Well, let's wait and see where we get to with the DMA. But I personally do subscribe to the school of thought that says when it comes to certain platforms who undoubtedly have a huge amount of power, I did not say market power, but there are platforms that have a huge amount of power. They're here, they're amongst us, they're producing huge benefits for society. No question about that whatsoever. But there are dangers. And the danger is that the power can become, can, not anything, can become market power. And it can become kind of market power that is capable of tipping into monopoly. And that as and when that happens, one might have a real problem for competition in the future. And of course, innovative and risk-taking companies deserve to succeed. No question about that, and they should be congratulated when they come up with wonderful products. But I would also like to think that other people can innovate and take risk, and have a hope of getting their products onto the platforms in question. And I think that there is a history of, what shall I say, difficulties for some developers, etc., in gaining access. And then you get into the question of, if there may be a problem of foreclosure, exclusion, call it what you will, is our existing Article 102, we're in the UK, Chapter 2, is it sufficient? or do we need something more or something different? And I actually think that for some very specific circumstances, one does need something different. And I think it has to be something that's a bit blunt, perhaps a bit crude, something that can be administered quickly and easily. And I think, frankly, that is what the DMA is. It's not perfect. Of course, it's not perfect. But it's here and it's amongst us. And gosh, the Commission is certainly getting on with it. You know, we've already had the bite dance judgment in the General Court. I think it's an immensely interesting judgment where the General Court more or less says to everyone, remember, this is not competition law. We're not doing market definition here. We're not doing market dominance. We're not looking at relative power of Facebook and ByteDance. This is meant to be an instrument that can be applied quite quickly and quite easily and quite expeditiously. And you know, that's what it's all about. I think the interesting question, I don't like regulation where it can be avoided, and I certainly don't like to regulate for the sake of regulation. But I think sometimes there are markets in regulation in which regulation is needed. And then the question is, well, what is the best, what is the most appropriate, what's the most proportionate type of regulation? And I think it's a fantastic thing to have this sort of live experiment going on before our very eyes, where you've got the DMA up and running in Brussels, and as of the 1st of January in the United Kingdom, we will have the DMCCA, which of course, in many respects is similar to the DMA, but in other ways is quite different because it's much more nuanced, it's much more adaptive, and you have to ask whether a particular firm has strategic market status, and you don't get there by adding up numbers or whatever it might be. So I think for the rest of the world, they've got a live experiment that they can watch playing out in public. And of course, there are other countries in the world doing their own particular things.
And if you look historically, we are at the beginning of this new regime starting being enforced on daily basis. How important are the first judgments in terms of even things which are said obiter dictum, in terms of this narrowing down the scope of this generous discretion granted to the enforcers by the co-legislators in the EU and in the UK indeed as well by legislators? Do they limit, or maybe we can see some elements of strategic attempts to nudge the court to adjudicate on something, but saying obiter dictum something other, which will channel the trajectory of the development for the future enforcement, or it's too sophisticated and academic?
Well, I think the way I would answer that is that I think that courts, when they're writing their judgments, and obviously in the EU, we're talking General Court and the Court of Justice, I think they have to weigh every word that they say. I think they need to write their judgments very carefully. I had the sense, incidentally, that the General Court did write its judgment very carefully in ByteDance. And I think if you read that judgment, I've said it earlier, it seems to me that the court is going out of its way to say this is not competition law as we have known it in Europe for the last 50 years. It is different. I haven't got the judgment in front of me at the moment, but there's a paragraph where they say, you know, competition law really wasn't quite up to the challenge of this particular phenomenon with which we're dealing here. And that's why, you know, we're not going to start with our market definition and then an assessment of dominance. Now let's find some theories of harm, and then let's see if we can find some jurisprudence that seems to support the direction of travel. Now let's have a discussion about effects and effects analysis. You know, Google shopping complaint was 2009 and the Court of Justice's judgment was 2024. A lot has happened in 15 years. So I think the courts have to write their judgments very carefully. I don't want to start talking about obiter dicta and stuff like that, because we lawyers must, I think, sometimes acknowledge that it is possible to be too lawyerly. It is possible to be too legalistic. One of the things I've always found a bit regrettable about the law of Article 102, actually, is that the courts will always say every case must be decided on its particular facts and its particular circumstances. And so you get a judgment like Post Denmark 2 or whatever, where you've got a historic monopolist, a service created at state expense over a vast amount of time. And then you've got behavior, which is a bit sort of, the pricing's a bit sort of flexible and whatever. And you maybe end up with a finding of abuse. And then things have been said in that judgment that lawyers will pick up and transpose to some situation which is utterly and profoundly different. And I really do think sometimes that lawyers and, lawyers sometimes, I think, rely on words rather too much. Words that then get taken out of context and applied in some totally different situation, I mean, if you go back 30 or whatever years to Tetra Pak 2, where you had this apparently extremely dominant firm that was found guilty of, let's say, quite a few abuses. But in the context of what appeared to be an absolute plan to smother any future competition. And so you get a sentence about vexatious litigation, maybe, or a sentence about, I don't know, any number of practices, leasing only contracts, part of the abuse. And then subsequently, in a totally different situation, you find somebody taking a sentence from that judgment and applying to something profoundly different where it just doesn't fit. And I've always had this feeling, actually, that sometimes, especially the lawyers, and sometimes perhaps academic lawyers, are a little bit too slavishly devoted to words in judgments. But that doesn't detract from my point that if I was writing a judgment now in the early days of the DMA, I would want to write the judgment very carefully, not least to avoid the kind of problem I've just been describing.
Exactly. A lot has happened in 2024, and we obviously have neither time nor the format to discuss in nuances, in details, all the major cases. But maybe if you can pick one or maybe couple which are of particular importance in your view for the future development of the
Yeah, okay. Well, look, I think I'm glad that the Google shopping saga is over. And whether you like the judgment or not, the self-preferencing in that case on those facts, let me stress, was found to be abusive. But I actually think that the Google shopping saga is the case that demonstrates the merits of having ex-ante regulation for some entities, for some practices. So that's a case, that's an intervention from which I think we've learned a lot. In terms of the actual judgments and decisions, I'm rather intrigued actually by the Commission's recent decisions, firstly in Apple music streaming, and then secondly, Facebook Marketplace. Because we have had this phenomenon in recent years in EU level, but also NCA level, and also in the CAT in the United Kingdom, of a much closer interest in what is an unfair price and what is an unfair term and condition. Because the treaty, chapter 2, talk about unfair prices, terms and conditions, but where's the jurisprudence? And there's very little of it. If it's prices, we all go back to United Brands. Terms and conditions, how much will you find on terms and conditions? Not a lot. But these two decisions of the Commission do find abuses in relation to terms and conditions. And of course, there will be appeals. So we'll learn a lot, hopefully, from that. In the meantime, a lot of these collective actions in the CAT that are making their way through the system are, to some extent, they're really consumer law or consumer protection law type theories of harm, if you like, being run as competition cases for obvious reasons, because that's where the collective action is and that's where the funding is. And anyway, Chapter 2 talks about unfair prices, terms and conditions. But we're going to see a lot here in the next couple of years, whether it's the boundary zone cases like Gutmann, Le Paterel against BT, the prices in that case, the cases against the water companies and the water companies' behaviour, and whether this has led to some kind of exploitation of consumers through misreporting of information. This is all terribly interesting stuff. And new jurisprudence is going to emerge from this.
And it looks that in the UK, with this new act, there is a significant reform in terms of enforcement of consumer law as well. Obviously, that's a territory for another discussion. But coming back to 2024 development, what is your stance on Illumina Grail and the future development of merger control?
Well, I think this is another hour's interview, isn't it? But, well, when I saw the judgment in Illumina Grail, the Court of Justice's judgment, when was that, 3rd of September, I thought, okay, I understand the arguments and, certainty and predictability and all of that stuff. I get it. And of course, a lot of the competition bar was jubilant because the Commission had received a very bloody nose. Okay, but I thought to myself, be careful what you wish for. Because what did we have with Illumina Grail? We had the Commission putting out guidance as to how it would accept references under Article 22, where the member state had no jurisdiction. We had about a year of that being in effect, and I think, 3 cases being referred, and so you could begin to see the kind of cases that would be called in, or sent, I suppose you'd have to say technically. And then we get Illumina Grail, and so apparently there is a gap. Do we honestly think that the Commission and the member states are going to leave that gap unfilled if they consider it's a problem? Of course it's going to be filled. And 8 member states have now given themselves some kind of ex post call-in power. And we've just recently had the NVIDIA run AI reference to the Commission from Italy in circumstances where, without a call-in power, that could not have been referred. And I understand there are 4 more member states now in the process of possibly going to give themselves call-in powers. So what are we going to have instead of the old Article 22 system with Illumina Grail? We're going to have lots of member states changing their laws, giving themselves jurisdiction. Well, is that really any better? And in the meantime, you've got jurisprudence out there like the Servier case under Article 102, which is now back at the General Court because the Commission's finding of dominance in that case was annulled by the General Court, but the Court of Justice has reversed the General Court. So therefore, the General Court's got to reopen the Article 102 case, and I suspect we'll find this time round that Servier is dominant, therefore leaving it to have to answer the question, was the acquisition of technology by Servier from generic companies that it did not then absorb and make use of, but which it destroyed, was that an abuse of a dominant position, contrary to Article 102? Because that's what the Commission had said. And the Commission is now investigating a case against Zoetis related to the treatment of osteoarthritis in dogs, where Zoetis had acquired a treatment for that problem from a competitor and closed the R&D program down. Is that an abuse of a dominant position? So, nature abhors a vacuum. And it seems to me that as a result of what the Court of Justice has done, all sorts of other possibilities have opened up for looking at these cases. And I wonder if they're more or less certain than what we had with the Article 22 guidance. So that's why I say, be careful what you wish for.
Which I also wanted to ask you a question based on the development with the DMA and the discussions underpinning it, and on the development on merger control, on latest cases, and overall, again, the tonality of the discussions. Looking at the broader socio-economic or geo-economic or whatever the vocabulary would be context, should competition policy and law continue being perceived as a kind of purely responsive instrument, as a kind of prosecutorial means to to bring infringement to the end? Or if you have broader discretionary competences, and my critical eyes do see broader discretionary competences within the DMA and the DMCCA, should we also expect from the enforcers being more strategic? Is it a toxic trajectory of development? Is it doable? Is it inevitable? Or it's just a little bit of the same, but with just broader muscles or stronger muscles?
Well, it's a very interesting question. I think as long as you've got a competition authority, with whatever powers it's got, it's not just an automaton that hears about alleged infringement and so acts. I mean, any authority with any sense will intervene with its limited resources, etc., in relation to matters that it thinks worthwhile investigating. So I think an authority all the time is operating in the here and the now. An authority isn't itself a kind of an algorithm where you just press a button and it reaches a conclusion. I mean, just for teaching purposes, I always used to say, suppose you're the competition authority in Arcadia and you're faced with two cartels that you know exist, and one is cartelising the price of textbooks for school children, and the other is cartelising the price of purpose-built billionaire yachts for very, very rich people, and you've only got the resources to do one of those two cases, which one will you do? You don't need to spend very long thinking about that, do you? It's obvious. You do what's important. And I think competition authorities have always done that. I think it's probably true to say that competition authorities think about these things nowadays much more systematically. And that's because you've got things like the ICN and the ECN and the OECD and UNCTAD and whatever, where competition authorities meet one another and discuss what they're doing and the pressures that we have in this country where inflation is terribly high, and that country where the biggest businesses all seem to own the biggest media entities and whatever, and they discuss what they're doing, but then they go home and presumably say, right, this is important and that is important and that is important. And in terms of just say merger control, it's blatantly obvious that over the years the Commission has been looking at mergers in energy sectors, and then you get down to the serious discussion about what remedies would you offer us in return for clearing this merger. and mysteriously you discover that access to a pipeline that goes from one member state to another member state will be made more available to third parties. Well, was that remedy absolutely required in order to alleviate the SIEC in that case? Or was the Commission perhaps thinking this is a good opportunity to do something about interconnectors? Discuss.
Speaking of Arcadia, you obviously are attending continuously as a keynote speaker different competition policy related events in different parts of the globe. And you definitely sense the development. Have you observed recently a jurisdiction or maybe a region where you would somehow say, wow, they are moving quickly in the right direction. They know what they are doing. They are full of enthusiasm and skills. And it's interesting to see how rapidly they go on.
Well, I am not going to name a jurisdiction or a country. I think that would be an invidious thing to do, because if you name one country, by implication, you're not naming other countries. So I think I'm a bit too wise to avoid that kind of pitfall. What I would say is, well, partly I'd repeat what I've just said. Competition authorities meet and they discuss what they're up to, but then they do go home and decide what is important for them. What is absolutely clear to me going around the world is that the days of the US EU duopoly are long over. And I think that this is absolutely to be welcomed, because I have seen that at first hand myself. A certain amount of almost condescension by the established regimes that, we know how you should do it, so listen to us. But I think that passed quite a long time ago, and there are plenty of very able authorities out there doing very good work adapted to their particular needs. And of course, don't forget, not every law is the same anyway. Sometimes laws themselves do express certain requirements and considerations and public interest factors and so on and so forth. So I think we live in a much more sophisticated world now than we did.
And maybe moving further with the first part of the question, this coincided also with the decline of law and economics, or the canonical belief in the wisdom and objective necessity of law and economics and ability to answer all the complex answers. Do we also see that the emergence of antitrust counterculture in some political alliances, and how dangerous it is? Is it dangerous, or maybe it's healthy competition of different visions, so to say? Are they maturing? Are they maturing quickly? Is it something which we have to be?
Well, I think we have to be careful here, because this could broaden out into some much bigger problem of the geopolitics of today. And I'm wondering how I'm just choosing my words carefully. I think there's little doubt that there are parts of the world where an incumbent government may not be entirely committed to competition law in its technocratic manifestation. And we know that there are competition authorities in the world whose independence is in jeopardy. Let's leave it like that.
Okay, so let us move to the jurisdiction where we have no doubts about the top tier maturity, competence, and basically being pioneering jurisdiction globally for antitrust purposes and beyond. United States, the recent Google case, the one delivered by the judgment delivered by Judge Merton. There are some interesting mechanisms which people from different camps discuss and question. Do you have any interesting observations about this development?
Well, it's for others to decide whether anything I say is interesting, but what I think about the US system is that whatever is proposed and whatever the judge decides, will go to the Court of Appeals. And I think whatever the Court of Appeals decides will go to the Supreme Court. And so it seems to me that in the US system, you almost inevitably end up with, the Google shopping kind of problem. That when would we get a judgment from the Supreme Court in Google search, say, or Google ad tech stack? 2027, 28? So, I mean, who knows? Who knows?
And this leads us perfectly to the conclusion about the performance of the DMA as the law and DMA task or DMA enforcement team or DMA team within the commission. What is your kind of express evaluation of this? People want too much from day one, obviously, but
well, I mean, you saw me just about to begin another sentence just now, and it was going to be to say that, frankly, I prefer the DMA system. And manifestly, they are pushing ahead very quickly. I mean, the obligations on the first designated gatekeepers became binding on them on the 7th of March this year. And the first accusations of infringement were sent by the Commission on the 25th of March. And the Apple preliminary findings were June. I mean, oh my God. You don't get 102 cases like that, do you? So let's wait and see where that is going.
excellent. Do you believe in regulatory dialogue?
Yes, I think I do. I don't believe in regulatory capture, but I think in the UK, my understanding is, I mean, I haven't spoken with the DMU at the CMA, but I read, what's unfolding, and my understanding is that it is very much hoped that there can be a regulatory dialogue. And I mean, if you are crafting codes of conduct, how can you craft an appropriate code of conduct without a dialogue? I think we always have to remind ourselves in this business that, okay, we talk about the platforms, GAFAM or whatever, but the business models are profoundly different from one another. I mean, I can see that this is a kind of a criticism of the DMA, that it has the 18 commandments, and some of those commandments are entirely inappropriate for X, but they might be absolutely spot on in terms of Y. So we want to do something more crafted, more nuanced, and you only get there, it seems to me, through dialogue. I personally would love to see a world in which, I don't like to say the two sides, but let's call them the two sides, if they could kind of acknowledge that, yes, there is something here. We understand why you want to look at it. You must understand that we're actually trying to do good things here, but there does seem to be a problem. Can we find a way of dealing with it? I mean, especially when you're dealing with something so technologically complicated, it seems to me that's quite a desirable thing. And when it comes to AI, I mean, which of us fully understands the whole world of generative AI and virtual reality and so on and so forth? So a dialogue, yes. A capture, no.
Richard Whish as academic. You've been recently labeled by Lewis Croft a teacher who taught half of the world competition law. It's probably an understatement, but definitely the what's going on in the academic minds and what's going on in students' mind. So maybe you can answer the last question, your recommendations, okay, dividing it into two halves. Recommendations to academics who are confronted with so many interesting challenges and opportunities, and also recommendation to students who see the many also emerging trends in competition law getting more and more popular and mainstream.
Well, to the students, I would say get a subscription to The Economist and the Financial Times. Because you've got to understand what's going on out there. Without a solid feel for the business world and all the things that are happening in it, there's no point in knowing about competition law. Everything's got to be really rooted in reality. So broaden your knowledge, understand the business world. Well, I've certainly warned lawyers against being overly legalistic. I absolutely believe that. And I absolutely believe that competition lawyers, I mean, I've said already, you've got to know the business world. You've got to understand what a widget is and how it sort of descends through a supply chain from being dug out of the ground to being sold to somebody over the counter or whatever it might be. You've got to understand all of that. But I absolutely think you've got to feel very happy with economics in the sense of sensible economic theories and the way in which evidence can be used to support those theories. I've always said that competition policy in practice is the economic analysis of markets within a legal process. And so the lawyer has to be comfortable with the economic analysis of the market, which is why you have to understand markets in the first place, and then the economic theories that we apply. And of course, the economists have to understand why you have legal process and why rules are important.
Richard Whish, thank you very much for sharing your fascinating ideas with all of us.
Okay, it's a pleasure.